case will be Commonwealth Land Title Insurance Company versus Higgins.
May it please the Court. My name is Joe Lang. I'm from Carlton Fields in Tampa, and I represent Commonwealth Land Title Insurance Company. At council table with me is Mark Brown. Commonwealth has been ordered as part of class certification discovery in a case supposedly presenting common issues to obtain from hundreds of law firms and other businesses across the state of Florida at its own cost over 300,000 closing files, most of which, or many of which, containing privileged information of third parties, not Commonwealth, and to produce that to the plaintiffs. This is an extraordinary and unprecedented order, particularly at the class certification stage, and it cannot stand. I would like to turn immediately to the privilege issue. These are not simply form files.
Did the order make any allow for any alternative approach?
The order does reference the plaintiff's suggested alternatives, Your Honor, but emphatically all 5 alternatives that are referenced by the plaintiff in their response to this brief, and any alternative that we know of to date, runs afoul of the very same problems that we have here. There are 5 alternatives on page 19 of their response. They suggest that we could produce the documents or provide access to them, and plaintiffs would do all of the work. 2, provide computerized access to the documents. 3, produce scanned documents. 4, provide access to a computerized database systems which may have information on prior owners' policies. Or 5, provide aggregate data. I'll start with number 5. We have provided aggregate data by way of a CD-ROM that has over 6,000 printed pages of information on it. As to the other 4 alternatives,
and you provided 2 pages, I guess, of the sample of the data that you provided on the CD-ROM attached to your
yes, Your Honor.
Brief. What that data obviously lacks is what would only be, I guess, determined by the file, and that is the extent to which the original premium was charged when it was in fact a reissue. You can't tell that from this data, can you?
I think that you can tell whether it was a reissue rate or an original premium rate from the spreadsheet. I think that...
But you can't tell if where it was an original premium rate charged where a reissue rate should have been charged.
I'm not sure you'll be able to tell that from the files either, because under the Florida Administrative Code, in order to get the reissue rate, the agent and the underwriter must have a copy of the prior policy. And you would be able to tell from the files whether there's a copy of the prior policy. Plaintiff's theory of the case, which Commonwealth disagrees with strongly, but their theory of the case is there is a duty to disclose the availability of a reissue rate, whether the prior policy is present in the file or not. And because many of these disclosures are made orally, not in writing, they won't be in the file, looking at the file is not going to give conclusive determination whether the reissue rate was offered or not. And you don't need, at a class certification stage, to look at over 300,000 individual files.
Well, has there been any discussion of taking a random sample of these files?
There has not been, Your Honor. Commonwealth would be amenable to a reasonable sampling approach, but that has not been broached. And that would be far more reasonable than over 300,000 individual closing files. And these are all, by the way, subject to subpoena. They're in the custody of third parties, non-parties, and they are subject to subpoena by the plaintiffs.
As I understand it, the respondents here argued, and I guess that the trial court must have agreed, that Commonwealth has control over these files pursuant to paragraph 2E of your contract with the title agents.
That is correct, Your Honor, but we disagree that the contract anticipates anything like this. We do have a very strictly circumscribed access to review the files. We do not have legal ownership of the files or title to the files.
But is that what control requires? I mean, doesn't control typically mean a legal right to have possession of the documents?
We have a strictly circumscribed right to review individual files. I don't think that there is any conceivable way that that contract anticipated that we would look at over 300,000 files. And we need to be clear as to what these files are. Many of these are commercial deal files in the possession of law firms that have far more than just the title work in them. These have attorney-client privilege communications. They are very expansive files. Even the Higgins file, which is in our appendix but is a non-attorney agent, that goes to 216 pages. It would not be surprising to see a deal file far exceed that. And
Can you give us a little context? In other words, you oppose class certification.
We do.
So what, as you see it, what are the issues on which certification will turn?
Well, the plaintiff has the burden to carry every issue under Rule 1.220 A and B, and we would hold them to that burden. But we clearly do not think that there are common issues here, and we will be arguing that there are individual issues as to whether disclosure is given or not given, but we don't think this wide-ranging discovery is going to resolve that issue.
Okay, so your position is no common issues.
We believe that the common issues certainly do not predominate over the non-common issues, and I think that we would come very close to saying no common issues.
All right, isn't one way to resolve that issue looking at perhaps a representative sample, but in some way looking at these files?
We don't disagree that these files have some relevance. We don't think that the burden of producing 319,000 closing files is justified for that small amount of relevance. But we also would highlight that we have not looked at these. There's not an unfair situation going on here where we've gone out and looked at 319,000 files.
Well, as you say, the burden is on them, so.
We have not looked at these files. We haven't even looked at a small fraction of these files. They have the subpoena power. If they really need these files, they can go and get these files with the use of the subpoena. They have all of our agent names. They have the spreadsheet that gives the policy number and the reference to put the agent and the policy together. They can go and subpoena these files through third-party practice if they really need them. This is an undue burden on Commonwealth to assemble and redact 319,000 files.
Well, if they subpoenaed the files, that you opened up here with your privilege or confidentiality argument, the subpoena wouldn't affect that, would it?
No.
Wouldn't you still be?
We still would have privilege issues, but I need to be clear that this is not Commonwealth's privilege. The reason this privilege needs to be asserted is these are the client's privilege in.
Well, let me understand then, since our access to actual files is somewhat limited, obviously at this stage, as is the plaintiff's, but are we sure that any claim of privilege is completely extinguished by this discovery order?
I don't think that privilege claims are extinguished at all.
They can't. I mean,
right.
I understand an attorney or an attorney agent in this case could not waive a true privilege issue, I don't believe.
I don't think the privilege issue is extinguished. Our point is that these files will have to be redacted in order to preserve that privilege. And redacting, it's a rough calculation, obviously, but if you take the Higgins file, which is 216 pages, and you multiply it by 300.
That's really the point of my initial inquiry, is that use of the subpoena as an alternative would still leave that problem or roadblock out there of close examination of every file and potential redacting. redaction of their files.
Yes, Your Honor, but I believe that if the plaintiffs were put to using the subpoena power, they would quickly realize they don't need 319,000 files to carry.
Are they looking, I guess, from your perspective, representing the carriers, let me ask you, are they looking, to your knowledge, for more information than what are the refinances, what deals involve refinancing, and of those refinancings, who was not at least offered the lower premium? Is there more than that they're looking for?
I must be honest, it's not clear to me what they're looking for, because their argument has shifted ground. Below at the trial court, they made the representation to the trial judge that they wanted the HUD-1 forms. That's what they wanted to look in these files for, was to get the HUD-1 forms, and our spreadsheet did not include the HUD-1 forms. And we don't see anything on the HUD-1 form that would be relevant that they don't already have. They say they want the names and...
Why do you say that? The HUD-1 form, for instance, in the right-hand column would reveal whether there's a seller or not. Wouldn't that be relevant?
I think that they can determine already whether it's a refinance or not. And what they say they want the HUD-1 form for is the name and address. And we believe they don't need that prior to a certification. If notice has to go out, then we can work that. But we are well before a certification determination, and they don't need names and addresses at this point in time, especially at this burden. On appeal, though, they have taken a slightly different angle, or maybe a much different angle, and they say that what they want these individual files for is to rebut our arguments about disclosure, that we will come forward with individual files that show that we did make disclosure, and they need to see 319,000 files to rebut that. I'm not clear which argument they're traveling on, but I don't think either argument works.
But there's been no ruling by the trial court on their legal theory that Commonwealth and or its title agents were obligated to make some disclosure about the reissue premium.
That's correct, Your Honor.
So that issue is yet to be resolved. Let me focus on another point, and that is the issue of unduly burdensome. Isn't that a fact issue? And hasn't the trial court basically decided that adversely to Commonwealth? And is that, if so, is that something that is appropriate for review on certiorari?
I believe that there are numerous cases, both from this court that we cite, but throughout Florida case law, that treats undue burden as a matter for certiorari. And because that once the discovery is granted, it's irreparable harm because the discovery has been turned over and there's no way to unring that bell. And there are numerous certiorari opinions.
Well, let me interrupt just a second. That's the cat out of the bag argument, and that's not exactly what this case is about, though, is it? It's not so much the cat out of the bag as how much it's going to cost you to untie that bag.
This is not just a cost case, and I will end on that because I do want to save some time for rebuttal. But I think it's very, very important to emphasize that we have business disruption problems here with all of our independent agents having to...
But my point, counsel, is that the classic case where discovery is granted and the courts say that's within the limited certiorari jurisdiction generally involve trade secrets, other things such as that. That's why I said it's the cat out of the bag. Your argument's a little bit more nuanced than that. You've got business disruption, you've got expense, you've got time, you've got problems with your agents. It's not the actual information.
It is correct. This is not technically a cat out of the bag case, assuming that all the privilege is redacted, which is undue burden. And, that's irreparable harm going through that business disruption. But there are numerous cases that we cite in our brief where simply the scope of the discovery is considered to be worthy of certiorari and quashing of the order. And we would rely on those cases. I don't think that you are limited to simply cat out of the bag cases. and I will reserve my 22 seconds.
Mr. Russell.
May it please the Court. I'm Scott Russell here on behalf of the Higgins. Certiorari is an extraordinary remedy, inappropriate here. The order appealed from represents a reasonable exercise of the trial court's discretion to oversee discovery. There simply is no departure from the essential requirements. There is no showing of irreparable harm, and the petition should be dismissed for a lack of jurisdiction. Class actions are intended to facilitate access to the courts where a class of victims is
What further discovery would you need on the merits?
Your Honor, there is
if you got that far.
There is a number of categories. First of all, let me say this. Every answer to the discovery that we've received so far, virtually every answer, is subject to a series of objections. At the trial level, as a practical matter, we are unable to be certain that we've received responsive answers. We have not received unequivocal answers that this is what we have. Let me give you an example.
What do you need to make the showing that has to be made to get class certified?
There are a number of categories, Your Honor. Names and addresses of people who refinanced and were overcharged.
Why do you need the names and addresses of individuals?
That goes to the issue of manageability.
I mean, you've got some named plaintiffs. Okay, you say it goes. So you're talking about numerosity.
Yeah, they've conceded numerosity, but there are other elements which the names and addresses are essential for, and I would cite the court to Coastal Physicians versus Ortiz. It's in our brief. The case indicates that names and addresses are necessary for certification. We need to know what were the...
And why is that now?
Who do we give notice to?
Well, that, again, you don't need to give notice unless you've got a class certified, right?
Your Honor, I'm sure that the insurer would like to build multiple steps in to make this take as long as possible. The Ortiz case...
My question was, there's no requirement to give notice if no class has been certified. Is that not correct?
We will not give notice unless the class is certified. That's correct.
All right, so on the question of certification, why do you need names and addresses?
We need to be able to demonstrate that we are capable of giving notice to the class. And our ability to gather that information is essential.
You don't want them to give notice? You want to bear that expense? Are you conceding that?
I'm not conceding that, Your Honor. But names and addresses are one of many categories of information that are necessary for us to obtain certification.
Why?
In order to demonstrate that the case is maintainable as a class action. That is not the best example, Your Honor, as you recognize. The core category...
Why isn't the sample approach, wouldn't that provide you with enough information to address commonality and typicality to go to the class certification issues? If you've got a random sample that a statistician would say would be adequate.
The best answer to that, Judge Van Nortwick, is this. Commonwealth has announced its intent to defend the motion for certification by relying on agents' testimony regarding disclosure of the reissue rate. They're going to apparently argue that it was our practice to disclose it, and many people just didn't want to be troubled to go get their owner's policy and elected to pay more instead. I'd like to call the Court's attention to our appendix, page 1, which is an internal memo from Commonwealth's parent company's counsel, and it attaches a letter from the Florida Department of Insurance. That letter indicates that the title insurer has the responsibility of determining whether the reissue rate is applicable. The word in the statute is the word shall. It's not a complicated word. If Commonwealth has announced it intends to use forms that are referenced in that appendix that its agents were recommended to provide to the refinancing consumer to document that they had been advised of the availability of the rate, if they intend to raise that as a defense on certification and they're going to claim that the class is not manageable, we're entitled to know whether those forms exist. They can't have it both ways, announce their intention to use the forms while at the same time claiming it's burdensome to actually produce them. The problem here that the insurer
But
is...
again, on class certification, if you looked at 300 files and did an analysis of what was in those files as to whether there was a form on notice or not, wouldn't that be adequate for class certification?
Judge, we don't want to find out at the hearing whether it is or not. The issues of commonality and of typicality would run into the issue of whether or not they actually did what they said they did for the members of the class. And the argument that 320,000 paper files have been compelled here is simply not supported by the court's order. The court recognized that there was a burden associated with this, tailored its order to minimize the insurer's burden. They persist in mischaracterizing this aspect of the order, but the order reads, to the extent the information sought cannot be derived except by review of paper files, that burden may be shifted through alternatives. To the extent that the insurers here have overcharged an estimated 320,000 consumers, a total overcharge we've estimated based on extrapolating from the total premiums, $65 million, give or take. The burden of compliance is proportionate to the harm that has been alleged. The fact that the discovery obligation will be extensive is no legal basis for relief under certiorari.
What do you say to their subpoena alternative argument?
Your Honor, the whole issue of agencies and controls is disposed of in their agency agreement. They have legal control over those documents, and although they are claiming that those are independent agents through whom they have done some business but for whom they are not responsible, it's simply at odds with the agency agreement. We've cited it in our brief. The court properly saw through that as a shell game. Their concern for the privacy of the consumers is commendable. However,
how do you handle the attorney-client privilege issue?
We're officers of the court. We've entered into a confidentiality agreement. The Higgins file is in the record here, and I recognize that's not through a law firm, but there is not anything I can identify as legitimately privileged information. In product liability cases, trade secret information is typically handled through confidentiality agreements and the experience of counsel in abiding by confidentiality agreements. And the consumers who they purport to want to protect are the very people who have apparently been overcharged, who have been a victim of a don't ask, don't tell policy.
All right, so you would oppose any redaction ostensibly designed to protect the attorney-client privilege?
I wish I had a good, clean answer to that, Judge Benton. Here's the problem, and I have to be honest with the court. This is a problem that runs directly into that privilege. What if that lawyer said to that consumer, you may be entitled to the refi rate? What if that's in the file? They can't shield the file from discovery while claiming that as a defense to the case. It can't be a sword and a shield. So we believe they have elected to do business through these agents. They've elected to decentralize their records, apparently in the possession of many, many other agents. Those are their decisions. But in terms of seeking certiorari relief from this court on a discovery order, they simply have not demonstrated any irreparable harm. They have not demonstrated any true departure from the essential requirements of law. And for this court to grant them relief will, in effect, say to the 320,000 or so Florida consumers, there are so many of you, we can't compel this insurer to respond to your legitimate needs for categories of information which you need to seek certification. And if I can get back to the more meaningful categories, what were their policies in terms of instructing their agents as to the disclosure of the reissue rates? We got off...
You can get all that, right? I mean, memos and depose the whoever supervises and so forth?
Your Honor, we could depose them, but I've been trained not to go to a deposition without the documents, only to find about the documents at the deposition. We would prefer, as we've attempted to do here, to request the documents and get unequivocal production that we know is what is available before taking those depositions. The form that is attached in our appendix, we originally got off their website. This is another issue that comes around to whether this is burdensome or not. Many aspects of modern insurance business are computerized, web-based. We agreed in the trial court, and the trial court ordered alternatives such as access to databases, spreadsheets. There are many alternatives to the paper files for the bulk of the information that we deserve. So neither burden nor control are genuine issues. We believe that the trial court correctly recognized that the insurers in these cases should not be rewarded for the scope of the overcharge. They should not be rewarded for the means by which they have decentralized their record keeping. We would ask the court to uphold Judge Davis's order, which we believe is necessary for us to seek certification.
Counsel, I guess where I am having some difficulty is the fact that just the economic burden of responding to this discovery basically shifts the leverage in the lawsuit. If you're talking about a potential liability of $60 million and they're talking about a cost of almost $7 million to pull together all of these files, the discovery itself becomes an issue in connection with the settlement. And so it seems to me, at least in my mind, that bears on the burdensome nature, where there ought to be many options short of full discovery that would satisfy you at this stage. I mean, ultimately, if you go to the merits, you're going to need to go to each file. That's probably true, but I don't know that it's true here. That's where I'm troubled.
We share the concern, Your Honor, and the judge shared the concern, which is why I believe he ordered alternatives to be considered. The order that's been entered would permit the insurer to mix and match different modalities for the different time periods, spreadsheets for some, scanned documents for others, electronic access for some. Then it would be up to us to determine if we were satisfied that we had enough to prepare for the certification hearing. If we then returned to the trial court and attempted to compel additional information, and if the trial court at that point said the alternatives have been inadequate, I now order all the paper files physically to be produced, we would be here under a different footing. We're not here yet. The order...
You'd probably be here with some of the title agents who are going to tell you who's going to pay me to go out to this hot warehouse and drag all of these old real estate files out.
It's possible, Your Honor, that they would want to be involved.
If I were a small real estate firm and somebody asked me to go dig out hundreds and hundreds of files, the title insurance company, I would say, I really don't need to write with you. I can write with somebody else. You know, go get a court order with me.
I don't want to argue the merits here, Your Honor. However, the overcharges, when it was written through an agent, my memory is 70% of the overcharge was retained by the agent. So arguably they've been paid and have a dog in the fight.
Well, they do, but their dog isn't in the ring yet.
Well, the evidence that identifies their dog is in their file. I don't want to go too far down that path. But the burden issue was considered in New York in a title insurance refi overcharge case. We've cited that case in our memo. The court found that review of the files was not insurmountable, and it was reluctant to halt the pursuit of the alleged misconduct affecting a very large number of consumers simply because it was a voluminous task. That is the way they've elected to do business. That is the scope of the overcharge. We believe there is no demonstration of any reason to relieve them of their burdens and we would ask that this petition be dismissed or denied. Unless there are any other questions, I thank the Court.
Judge Benton, you asked what further merits discovery would be needed. That's exactly correct. This is full merits discovery, what has been ordered, and it's pre-class certification, and I don't think we heard any identifiable need for these documents for the class certification determination.
But counsel, one of the problems we've got here is I don't see any evidence in the record with respect to the undue burden of these options, other discovery options. And we have an order of the trial court that's sort of imprecise in terms of the type of discovery that the trial court thinks is going to occur. And that's where I'm struggling.
Yes, Your Honor, it is imprecise, but the plaintiffs have put a fine point on what the alternatives are. In their response, they have identified 5 alternatives, and all 5 of those alternatives do not work. As to the aggregate data, we have provided the aggregate data that we have on a CD-ROM. The other 4 alternatives, I can explain very quickly. They all involve first compiling this information, assembling it, organizing it, and redacting it for privilege. It's just different ways of saying the same thing, but they talk about scanned documents. They talk about computerized databases. Maybe some of our independent agents have those things. Maybe they have scanned documents at an individual law firm. Maybe they have a database at an individual law firm. May I continue?
Yes.
Okay. But they all would have to be assembled and redacted. Commonwealth does not have all of that information they are seeking in some sort of scanned document form or some sort of computerized database. These are out at individual law firms, or frankly, because this dates back to 1999, probably out at storage facilities somewhere. But the alternatives that they put a fine point on in their response, they all fall to the very same objections that we have here. And Judge Van Ortwyk, you also observed that this is a monumental cost. And it also, I don't think you used the word monumental, but it will be a very big cost, and it does shift the leverage in this to have to produce over 300,000 individual closing files pre-class certification. There's a very big leverage issue at play here, and the Commonwealth should not have to bear the burden of this. They have the full subpoena power. It's irreparable harm for Commonwealth to bear the burden of this. Thank you.
We'll take a few minutes to let the petitioners change.